Okay, well, we're going to start again here in Chapter 10 of Litigation. We're back to talk some more about this e-discovery and ESI. Remember, we said electronic stored information. That's important. We're also going to touch on rules of procedure and look at the differences between federal and state rules in some areas. And then, as we said earlier, there's a lot words that are involved here that we're going to try to get you involved in defining some vocab words, and we're going to share some of those with you. So if you can put those down on paper and turn them in, you get extra credit for that. Another thing I point out to you, though, is that I will give you kind of a short definition for each one of these words. It would be nice, I would appreciate it if you would go out on your own, show a little initiative, try to find out a little bit more information on each of these words. So here again, modern concept, electronic stored information. This can be problematic actually, because what do we really mean by that, electronic stored information? Well, I made an actual list here of all the different parts that are involved here. So I'm going to take this little part off here, and then I'm going to touch on what we're really talking about. Okay, first of all, you can go into network infrastructure. You get into some of these large companies, and what do we really have in terms of a system here? You're getting into a thing where you almost need an electronic engineer to be able to, somebody with some heavy-duty computer skills to explain some of this. What about, so you want questions also on internet access, who's your provider? Is it Comcast? Is it some other company? Some of these large companies use different kinds of ways to get the internet. Is it a T1 line from the phone company, for example? Is it a Comcast Roadrunner? What is it, Okay. Also, what about your computers? What kind of computers? What are their capabilities? Do you use the cloud? You guys, do you store information off-site on the cloud? Do you have servers? A few years ago even, we didn't even know, we've never heard the word cloud. But it's funny because I've got a couple cousins that are big in computing, and they were talking about that very concept. Didn't even have a name yet, but they were talking about this concept of storing everything. And what they're really saying is that these handheld devices and iPads and things like that, eventually, you don't even need a hard drive. You just go off-site all the time, get the program right off the cloud, type up the letter, send it out as an attachment to an email, store it in the cloud, so everything's in the cloud. Well, if that's the issue, you need to know that if you're doing electronic, background checks. Now, email, of course, is probably one of the biggest things, the actual emails, and you're going to want to talk to them about, well, do you use email? How do you use email? What kind of an email account do you have? This type thing. Have you ever sent an email concerning the plaintiff? Well, yes. Well, how many? Be specific. Who did you send them to? What did you talk about? Let us say that you have, just like there was a case on this, we used to talk about a lot in 103 in civil procedure, and there's a case where a woman was basically, her whole reputation was besmirched by these guys, they foul language, all this kind of stuff talking about her, and she brings a lawsuit over harassment and that she couldn't break through the glass ceiling, she couldn't get a promotion, all these different things like this. And these guys have just like a basically breadcrumb trail of terrible, nasty emails, back and forth between the two of them, and then they try to destroy those emails but they did not know that there's ways that they're backed up by the company. So if it's AT&T, if it's Comcast, who it is. And so what ends up happening is it really made them look bad. It increased the damages because they actually tried to defraud the court and tell the court, oh, well, yeah, we had some emails, but just in the normal course of business, we destroyed those emails. And that'll come up again, especially in the state rules in Indiana. So basically, you can also get into telephones. What about cell phones? What about wired landline phones? Did you record any of your conversations, for example? This can be electronic. All that stuff can be taped. It can be put on the cloud as an electronic file, an MP3 or an MP4. Here I am making a video. What if your company did a lot of videos of board meetings and stuff? That's what got Nixon into trouble in the Watergate. And this is before your time, I'm sure, but this is when I was just really coming of age and understanding, how dirty and rotten politics is. And so, a lot of the recordings that were done in his office could be another kind of an old antique, but an old example of this electronic media, which is recordings that are kept, in the normal course of business. And here again, they destroyed some of those recordings. It could be another example of, the problems that you can get into, trying to force people to, be forthcoming with some of these records and things. Also important to keep in mind, plaintiffs can file a motion for leave to supplement. You find out things in your first set of interrogatories, usually end up having follow-up interrogatories pursuant to Federal Rule 33A and 26B2. Now keep in mind, however, that the state rules are a little bit different on this. I'll touch on that a little bit more later. But at least under the federal rules, there is a requirement that you can supplement with additional interrogatories because there are severe limitations, only 25 interrogatories allowed in federal court. There can also be stipulations where both sides can really be forthcoming, which is very rare. They always want to seem to play games. Also, order to supplement. The court can see something or find something in the course of the case, and they can just order the parties, or they can order on the basis of a motion by one party to supplement interrogatories and put a stall on the case till they get the answers to some of these kind of questions. So those are important things to consider when we're looking at this ESI. It is anymore becoming just a huge issue and could really be a course in and of itself. Just kind of like, the 203 course, really, we've debated that at times. Well, you can include the SI without being asked to, or you can be required to based upon a court order. One of the things that you've got to look at is there can be costs involved, and sometimes, trying to restore these emails and things like that, you get into a lot of cost. And going back to that motion to compel that I was talking about in the other video that I did, in other words, compelling the costs of reproduction of, basically records that were destroyed. The question that's going to come up on that is, what was their motivation? I mean, were they motivated by what we call animus, or was it just normal course of business that every so many months they destroy some of these emails and stuff to just make room? Well, one of the things in order to try to avoid this is that they've got a records requirement that you've got to maintain 5 years of records. Now, let me say this. There's some other rules out there, that you can get into where there's these different rules and different agencies and stuff, administrative, like the IRS, versus the federal court, things like that, where they can have different rules. But one thing, you don't want to destroy anything in a big company or even a law office Me, myself, I kept records in my office, files, client records, client information. Some of them were 20 years old. Part of the reason for that was that when there's divorces, for example, you got kids that are like 3 when the parties get divorced. Well, when did they finish college? Well, when they're 22. So you got to keep those records at least 20 years in order to cover when those 3-year-olds finally finish college. So these are things to consider in the law office, as well as, when you're trying to sort out what's going on with clients and stuff. And if they tell you, well, we destroy all of our records every 90 days, that's not good. Also, issues of privilege. Sometimes you can try to claim, or people will claim, that some of this ESI is privileged information, and that necessarily isn't true. You can only file an objection, ask the court for a ruling, and then whatever the court decides, that's what you've got to go with. Okay. Some important words in e-discovery, and I'm going to put some of them up here. And a lot of these words just as a young person, you've heard these probably. But there are some of you out there that are older like me, so you need to understand that. Well, application, we think of it like a job application or something like that, but it's totally different in the world of software and so forth. So application would be, an example would be like Word, a Word document, So it's software, basically, is what it is, okay? Attachment, well, we know what attachments are when we're sending out pictures of our kids or our grandkids. And so any kind of a document, picture, anything like that could be attached to like an email message. Okay, backup. We know that a lot of times we might have like a 1 terabyte hard drive, external hard drive, and we want to back up our files every so often. Well, large companies, they back up on like the cloud or these huge servers. So we're looking at server or cloud type oriented service to back up all the information. Another important word is burn, okay? And we know that, like burn DVD, okay? Or you could burn a CD. So basically what that means is you're taking records and you're putting to some kind of hard kind of a product where you can have removable media, where it could be some of this information is too large, and so maybe you're a mid-sized company and you want to do backup, but instead of using off-premises services like a server or the cloud, you just burn a DVD, so that's another possibility. Computer forensics, this is important, and this is a wide new field, and it's something to consider if you're interested in going the criminal justice route. You could branch off of paralegal, go over into paralegal and criminal justice by getting over into computer forensics. But computer forensics involves investigation and analysis techniques for a number of different things, including company records, accounting records, we've said before, like emails, if someone's like stalking another person, they might keep emails of that person. You can also have records of things like sexting, texts from the telephone. All these things can be used to try to help to prove a crime. Also, it can be involved with companies in access to records, development of records, like someone's trying to steal an invention, something like that. Maybe the blueprints are stored on a computer and someone tries to get in a computer and steal that data. Also fraud, like theft with a computer of someone's ID. So basically what we could get into there is like credit card theft, a number of different things on that. I've seen a lot of different examples of that, even telephone charge cards for like collect phone calls using a card. That can be a form of that. Concept search and litigation can be like broad-based searches for general information, and you can be looking at information on a person. Just go into Google and Google on a person's name. You can also have that on, like for example, like I was saying, here's ESI, type in ESI interrogatories and go to Google and you might find better definitions, than what I've given you, or more information. So it can be any kind of a synonym, thesaurus type language, definitions, dictionary type stuff that you can find using concept search on different kinds of computers. Deduplication or deduplication. And that's either hyphenated or not, but we're going to put deduplication. Okay? And what do we mean by deduplication? Deduplication. It's basically identification and separation of exact or nearly exact files. So somebody maybe has the same file, made some slight changes in it, but there's a record of it kept on a server. Let's say, for example, somebody has a record from a doctor that says, well, there's not a thing wrong with this guy, okay? And they want to turn it in to an insurance company. Well, they want to go in on an insurance fraud investigation on this person and see just who tampered with the doctor's records. And so there is a way that you can actually erase content, and all you keep is like basically the heading of the letter that's been scanned into a computer, and then you go in and change it from, there's nothing wrong with this patient to, there's a lot wrong with this patient. I don't know if he'll ever walk again. You could go into great detail. I've actually seen this done, so that's why I'm bringing it up. And it was just really done as a training exercise. It wasn't done that someone really did that to me or did that to my client, but basically deduplication. You can see where someone scanned a document and changed it, where you can set the two documents next to each other and show where the changes were made in that document. Document management system, it goes into some of this whole thing about how is your whole system set up in terms of your company, how do you handle it, what are your policies on this. I'm just going to put document MGT. And so basically you try to get that. That helps you kind of trace back into the system and find things that you're looking for. Deleted files, and this is a major issue. And there's deleted files that are deleted in the normal course of business, but is that a violation of the law? There's deleted files that are deleted with a purpose. We can't let them know that I called that woman a bitch, something like that. So, or even worse stuff I've seen. I used the N-word in that email. That was a bad mistake on my part. And so these deleted files can really come back to haunt you, because nothing, I'll just tell you, is ever deleted. The question is, are you willing to spend whatever it costs to find that out? So very important, that we be careful when we're working with a client to make it clear to them that nothing is ever really deleted out of a computer system. EDD is electronic data discovery. Electronic data discovery, okay? Electronic data discovery. And that's important too, something to consider. It goes hand in hand with ESI. So basically ESI is just the objects stored, electronic stored information, and EDD is acquiring that ESI. So you could shorthand it by saying, well, I'm going to perform EDD on the ESI by the company LexisNexis. Well, how big would that be? It'd be huge, So, email strings, where you can get into like email, A to B, and then there's a reply, B to A. That's what we call an email string. And it goes back and forth, back and forth, back and forth. And they have a whole conversation. And then some of these email strings, that's your smoking gun, because, they just get on a gab fest about, oh yeah, I hate that woman, and blah 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 blah, is very terrible. What they can do to themselves really can hurt themselves. Well, e-discovery is really another word for EDD, or electronic data discovery. E-discovery amendments is basically where you discover something, you think you know the answer to a question, and then you find, oh, I don't want to misinform the court, so I need, ask the court for leave to amend this whole thing because I made a terrible mistake. Well, some things to keep in mind on some of these is some of the rules are important too, because Rule 26, which is disclosure under the federal rule, it's just a general rule in the state rules, but in the federal rules, this ESI should be disclosed right up front. You should not hold anything back, because the federal rules, they are very adamant about disclosure. Basically, disclosure is very important. Automatic disclosure, okay? And that's what this stands for in the federal rules, is automatic disclosure. Now, there is no such rule in state court. You have to ask for it, okay? And so that's another side of the coin. But in the federal court, and if you practice in federal court, you're going to get burned if you think you can play fast and loose with the rules like people do in state court, and I've seen it many, many times. Rule 26 can have enhanced meet and confer requirements. The judge can actually require the parties, even by local rule, to have a pre-trial according to Rule 26. In other words, they want the parties to work this out at the earliest possible opportunity. So Rule 26, very early rule in the discovery process, get together, try to sort this out, and settle the case. That's the whole idea of it. There can also be inadvertent production of privileged information. You may want to go back and say, hey, we didn't intend for the parties to see that because it's privileged. So you can try to put the horse back in the barn, but generally speaking, that's very hard to do. Basically, production of information not reasonably accessible. This can be emails, property, electronic items that were eliminated, destroyed, could have been destroyed by accident. I remember one time I had a videotape of a lineup, and I said I wanted to copy that videotape, and the deputy sheriff supposedly destroyed that videotape by accident. He actually just taped over it. There again, that was a situation back in those days where that was deleted. But now today, generally speaking, nothing is really deleted. Production of ESI in response to interrogatories under Rule 33. Remember, Rule 33 is interrogatories, and so ESI can be a part of the interrogatories. Generally speaking, this can be very important. You want to be cooperative, especially in the federal court. Rule 34 is can be like a request for production, and request for production. You might produce CD or DVD of some of these electronic records. They have these couple different safe harbor rules. Both state and federal have what they call safe harbor rules, and when we're talking federal, we're talking Rule 37 is a safe harbor. What do we mean by safe harbor? What it's basically saying is, hey, we had no motives. Basically what you want to argue, we cannot produce those records. The cost would be prohibitive. Some of this information was deleted by accident. It could possibly be recovered, but the cost would be in the thousands of dollars. In this case, just isn't really worth going to that kind of trouble. So that's a routine, good faith operation of the electronic system. Something was destroyed, and there could have been a fire in the building, for example. Your motherboard could have overheated. The whole system could have collapsed, and you can't even get anything off that hard drive anymore. So what do you do in that situation? Well, that stuff can be recovered, but it's very expensive. It costs a lot of money. So the safe harbor provision would say, hey, it's just not worth it to produce this information. We didn't do this on purpose. It was just a good faith failure of the system. It just broke down. We're doing the best we can here. So it'll be up to the judge to decide, what to do. But the whole thing is he can rule under Rule 37, that there is a safe harbor, that it wasn't anything that was done on purpose. Now this can have a very damaging effect on a plaintiff's case. And so plaintiffs are obviously going to argue against these kind of safe harbor type provisions. Well, other important ones, real quickly, we're going to cover include electronic images. And that would be like a JPEG. And that's basically a picture, okay? Other types, this is your probably best type of picture. Other types, you've got PDFs, which are kind of like a picture. It can be a document, but it's saved kind of in the form of a picture. The value of a PDF is it can't be tampered with, like I was saying, that Word documents could be, like a letter that a doctor wrote, something like that. If it's a PDF, it's very obvious when you change PDFs, unless you have some really high-powered software. Another possibility is a TIFF file, but the problem is these are huge, very expensive, and it's an old technology, and so people are moving away from it and moving more to either JPEG or PDF as a storage method for a single image. Basically searches, papers, file server, all these things relate to ways of keeping records, and I'd invite you to look at this at your own pace and your own leisure. A lot of this is standard information. There can also be what they call an MD5 hash, which is a digital fingerprint. You can kind of trace back to what computer prepared a certain document, who normally sits at that computer and that type thing. Spoliation is destruction of evidence. It is also, in other words, purposeful destruction of evidence or failure to preserve evidence. So that's important, to keep in mind. Just real quickly, too, I want to hit on some of these state rules. Once again, I pointed out that just like with the feds, Rule 33 is the rule for interrogatories in the state. The only big difference on Rule 33 is there is no set number of interrogatories. Now, that's where you want to look, again, like I mentioned earlier, to local rules, because local rules, a lot of times they'll say 50 or 25 or whatever. Answers, Rule 33B, that's by the responding party. A lot of times this is 30 days, but it can be stipulated to under Rule 29 or can be shortened by the court, and that's something you've got to watch very carefully. Understand that each interrogatory is answered under oath, so that's very important. Objection, signature, here again has to have some type of an oath included in it. Use of interrogatories are the same as the federal rules. So generally speaking, you can use them to cross-examine. Sometimes they can be used if the party's unavailable. Let's say a person dies, but you took their interrogatory. Well, they can be presented in court because the opposing attorney was present, was able to cross-examine, so it does not violate the Confrontation Clause. A number of these things that we're looking at, they kind of are the same between the federal, but you want to watch. Certain of these are a little bit different. Important difference with state rules Rule 26 is totally different, but note in Rule 26A1, it does refer to electronic format, and it also talks about the requirement that people serve opposing party with copies of electronic documents. So the interrogatories have to be served on a CD in addition in a written form. And also they have to also say that they're unable to do that, like you're old school and you don't even have a computer. Well, that's kind of hard to believe in this day and age, but they still do have kind of a safe harbor provision there under A1B. Scope of discovery is general. It can go into things like insurance agreements. It can go into trial preparation. However, if it's a work product, then attorneys are a lot of times going to argue that they're not going to provide that information because it is, in fact, work product, and you get into a lot of argument. Trial preparation experts, a lot of times you can take the deposition of an expert, or you can do that by written questions, or you can even agree to do it by interrogatories. Claims of privilege, this all needs to be sorted out in area subpart 5. So that is, again, very important, 26B5. Protective orders can be entered. This is state court rules, remember. And that's saying that, like I said before, on mental health records, you cannot go into these mental health records. So that can be very important. Another thing to consider is that some discovery can be conducted pending appeal. So if you, for example, the case is over, you lost, you won, whatever, but you find out some new information, it might be possible to get a court order to do some interrogatories or take a deposition, of that person. We've talked about some of these in the past, so we don't want to dwell on them too long, but generally speaking, the rules between federal and state are about the same, but it would be good to look at Indiana trial rules and just kind of compare them, set them next to each other. I know we've had an exercise already on this, but you might want to take a closer look when we get into this Rule 33 and interrogatories, because there are some specific differences. Rule 26, Rule 33, Rule 34, and Rule 37, very important. Now, it's interesting, but in Rule 34, which is more in production of documents, you can actually ask for other people, like employers, to provide records like wage records, bills, medical bills, that type thing. And that can be done as a part of interrogatories, or it can be done separately, either way. Rule 37, once again, remember at the state court level, they also have a rule for motion for order compelling discovery. Somebody fails to do the discovery, you can go to the appropriate court. That sometimes can be a different court than the court you've actually filed the lawsuit in. If someone is in a different state, for example, you file a motion. You may say the person was evasive or incomplete, and that they refused at all to answer or allow inspection. And you can also ask for expenses. You can expenses of the motion. Even after motion to compel, if a court enters an order, if the person fails, then the sanctions can become more harsh. And like I said, if it's a plaintiff, for example, the whole case can be dismissed. And if it's a defendant, the court can, in some rare cases, enter a judgment for costs and some of the expenses that are in particular involved in a case. Parties fail to attend or fail to serve. That's Part D of Rule 37, and that basically is where we get into this whole thing about expenses, or it can go into, and that happens a lot. Somebody gets sick or whatever, and so then it's up to the judge to decide, do we make them do something. Well, 37E, this is where you get into this whole safe harbor thing. Again, and this is true in the state court, 37E, what we call safe harbor. Basically, hey, normal course of business, we destroyed these records. It was not done on purpose. It was not intentional, that type thing. So here again, that can be an issue. Okay, well, basically, those were some additional things I wanted to touch on. Be sure to look at these and develop some notes, some definitions. If you want to go outside, dig up more information, share that with me. If I see anything that you send me that you really think is important, I'll share that with the whole class and perhaps even give you extra points for that. The disadvantage of these lectures is they want them to be like 15 minutes long. The problem that I get into sometimes on some of these is they end up being like 30 minutes long, and that can be kind of problematic. So that's why I'm trying to divide them up a little bit so we don't spend too much time on them. Okay, well, that's it for today. Good luck with this, and let me know if you have questions or problems.